All right, welcome back to the House Judiciary Committee, and we're going to turn to H 44, which is on third reading today, right? Down the side? No, it's
No, it's still second reading.
for 44.
Yes.
Oh, for some reason I thought it was third reading. In any event, we'll take.
Yeah, so I just confused myself when I just mentioned you. So H 105 just got voted out this morning. So it'll be noticed tomorrow, second reading on Friday, H 44 second reading this afternoon.
Okay, so we'll take our chances that there won't be any further amendment on the floor. And if there are, I'm sure you'll tell us, but we'll take the time now while we have some witnesses to go over what is on second reading in the Senate.
Yes.
It's that time of year where we have to be ahead of the game a little bit. So over to you, Ben.
Great. Thank you. For the record, Ben Novogratski from the Office of Legislative Counsel. If you just bear with me while I pull up the comparison document that I have to say did not translate very well when I sent it over to all of you. So what I'll do after the fact is just do a short side-by-side of the changes, and I'll send that over to Nate to distribute. But I will quickly go over the changes between the as passed by a House version and the Senate proposal of amendment as it currently exists prior to second reading on the Senate floor. So with that in mind, there really only are three changes, if you will, between the two versions. The first one is right on the first page on lines 11 through 16. So there's this, and this is to address the federal regulations about anti-masking of crimes for CDL drivers. So essentially, under a series of CFR regulations, states are required to report CDL convictions for CDL holders because of the nature of their violation. So this can be a series of things reporting. There's a national database for this information to report any sort of criminal conduct. And so this language that you see here was suggested by the Department of Motor Vehicles to be compliant with those regulations, where essentially, since these would be in family court proceedings, they would be confidential and therefore, due to those confidentiality requirements, may run afoul of those federal anti-masking regulations. So this makes sure that any CDL drivers with an offense or violation other than parking, vehicle weight, or vehicle defect violations are reported to the national database. And that was language that was suggested by the DMV. Any questions on that compliance language?
Nope. Good.
We're going to go slam.
Oh, I'm sorry. Didn't see you
Did transportation take testimony on that?
No, but I do know that there is another bill that they are dealing with that is incorporating the same language.
Okay. Thank you. What?
Okay. The second change is in subsection J, which was added. This is on page 5, line 13. So if you see here, this is what created the obligation for the person to go through the evidentiary blood sample. Previously, it said a person suspected of violating the section shall not refuse the collection of an evidentiary blood sample. And it's now being changed to an affirmative obligation, shall submit to the collection. That was due to discussion raised, I believe is from the Defender General's office of inadvertently implicating the implied consent. Since you're talking about refuse, it's sort of the antithesis of consent. So to kind of move away from language that may somehow be construed to implicate that consent doctrine, it's just that affirmative obligation to submit to the blood draw. So that's the affirmative obligation that's imposed on the individual, but there is no penalty for not submitting. That portion has been changed to still have a penalty, but it creates a knowingly mental element. So previously, it just said someone who refuses the collection of an evidentiary blood sample. So theoretically, that's a strict liability crime. If you just refuse in any form. So there was discussion or testimony centered on if someone's too incapacitated to provide that blood sample or at least kind of participate in it. Could that be construed as refusing? And do you really want to criminalize that potential fact pattern? And so the Senate Judiciary Committee said, well, let's create a mental element where you need to knowingly hinder the collection in order to be charged with criminal refusal. So essentially what that means is that you have to be aware of what you're doing to the extent that it's likely you would know that your actions hinder the collection of that blood sample. So to kind of put to put this in context, it would have to be some sort of affirmative action to hinder that collection rather than just sort of being just limp and incapacitated. That may somehow be considered a refusal.
Couldn't that apply to a breath sample as well?
Yeah, but the breath sample is different for those criminal refusal because it's not really conduct related. It's what it is that if you've been previously convicted under 1201, so of a DUI violation, that's how you can be charged with criminal refusal again if you refuse. And then if you're involved in a crash or collision, that results in serious bodily injury or death.
About this, I think when I wanted to get back to the implied consent, study, whatever, very often they're too inebriated to understand what's going on, and it is behavior. It is a behavior type thing. They don't understand it, and they're not necessarily trying to give a breath sample. They're just don't get it, and they're completely uncooperative because of their inebriation.
Right. And that was the policy choice that the Senate made after kind of hearing the various testimonies.
So just I understand that clearly based on what you both said, that so knowingly hinders would not goes beyond what Tom's talking about, right? The as you said, just so inebriated, you can't, we're not
You're essentially incapacitated. Yeah. But you wouldn't necessarily know because you don't have the mental capacity at that point to know what you're doing, to know that you're actually hindering. Well, so what this change does is create sort of that mental element where you have to be aware enough of your actions to know that they will likely lead to the hindrance of the collection of a blood sample, as opposed to before, it would just be anything that could be construed as a refusal, you could be charged.
But Angela?
Yeah, I'm really curious how that's determined, but I guess it's very fact specific.
Well, go ahead. Lots of people mess around to delay the inevitable drawing of the breath or blood by wasting time. They do it on purpose. So then you have to go to the blood room.
So that would be
Or charged with a refusal because they know what they're doing, they're hindering it. They're sucking instead of blowing, with the machine over and over and over again.
So you know it when you see it. Yeah, as a law enforcement.
And this would just be for the blood sample, not the breath sample.
Yeah. Also, alternatively, it can take a long time because it's a confusing process, and when you're drunk, it can be sort of hard to know what is going on. So maybe it's not intentionally making it late. But my question was just, so it could be an affirmative defense to being involuntarily impaired to the knowingly hindering the collection, even if they said, if they're drunk and they say no. So it's not a limp. They're not able to sort of agree to it or anything because they're so impaired, but they are impaired and they actively decline the test.
Mhm.
That could still apply under the.
Yeah, that could be a litigated issue. Whether or not it's termed an affirmative defense or not, I'd have to think about it a little bit more. But yes, that could be something that could potentially excuse the behavior if it's litigated that way.
Okay.
And that's the extent of the changes.
That's it?
Yeah, between the House and the Senate versions.
There's so much.
Wow,
Good work.
well, that's right.
And like I said, I'll get that small section by section to you all, so it's a clearer than soft words compare.
DUI, having issues getting somebody to blow. And Ian spoken like a true defense attorney over there. So how do I want to word this? As far as charging them with refusal or going the blood route, which happens more often? The refusal.
I think-
Will you charge them with the refusal?
Yeah, if they're messing around.
Right.
It's not very often you get one so inebriated that they don't. You can usually get them to cooperate,
Yeah.
but then some just don't make wise decisions, obviously, when they're very inebriated.
Well, they already made
And
one.
don't understand what they're doing or what the implications are.
Yeah.
All right, thank you, Ben. Dennis Whitmans, if you can join us and weigh in on these changes.
Dennis Wigman's Traffic Safety Resource Prosecutor, Department of State's Attorneys and Sheriffs. So on the first change, we agree with the Department of Motor Vehicles. Last year, the House and Senate passed a bill that did help to conform Vermont law with that of the federal law as it relates to commercial motor vehicle licenses. I think we discussed it, but it might help to refresh your recollection that commercial driver's licenses aren't state issued, they're federal licenses. Essentially, when you apply and are granted that license, your Vermont license is given up. And so you now have a federal license to operate a commercial motor vehicle. Obviously, because you're a big part of interstate commerce, it makes sense that we don't have a bunch of 50 different laws as it relates to commercial driver's licenses. And so there's a nationwide program through the Federal Motor Carriers Safety Administration that addresses these licenses. What masking is that essentially we are, as state prosecutors, for lack of a better word, a puppet for the federal scheme. And that is that if there is actual evidence of DUI or other infractions, we're not allowed to amend those cases. Basically, they have to go to trial if the facts are there. We can resolve them in a plea agreement if there are evidentiary problems, but if the facts are there, we're pretty much, our hands are tied as our judges or anybody else involved in the process. And so all this does is it says that because we do consider 18-year-olds to be children in Vermont, 18 and above is the requirement in order to obtain a commercial driver's license. Those also have to be reported in conformity, not only with state law, but also the federal law. And so we agree that I think is appropriate under the circumstances. With regard to hindering, it may assist to comprehend what the defense of voluntary intoxication is, and that is that you have gotten yourself drunk to the point where you can't appreciate the natures of your acts. Pretty simple definition. And it is a case-by-case analysis. You have to really kind of look at the facts and say, this person really has no idea what's going on. Under those circumstances, the only way to get a blood warrant is because under the officer's, totality of circumstances, considering all of them, under their belief that the person is incapable of giving a breath sample whatsoever. That's different than the refusal. Refusal is always required a knowing element to it. A person can only refuse through words or actions or a combination thereof if it is an expression of their unwillingness to consent. I'm not familiar with a single case where someone's been charged with refusal because they're so impaired that they can't provide a breath or blood sample. In fact, the Constitution supports taking blood samples from people who are unconscious, for example, who can't give, and then we go through the applied consent after the fact with them. So from our perspective, it wasn't an issue going forward. We discussed this same or very similar language in one version of this with you all. We settled on refusal based on Judge Zonet's input, and why not use phrases that are common, phrases that have meaning in DUI context. A lot of the concerns that were raised were addressed through Schmerber v. California, through North Dakota v. Neville, and then in our state, Justice Johnson and State v. Morale determined that these aren't compelled speech issues, that they aren't, because a person is given the option, either you capitulate or you don't. From our perspective, however, we don't have a problem with the way that it's worded now. We believe that hindering, refusal through words or actions is hindering. It's our case law. I think it's State v. Bedard actually says that. So from our perspective, we don't think it's a problem. As far as requiring a person to submit, we think that it also fits because it's in the same, legislative scheme, if you will. So we support the language change, even if it will lead to possible future litigation on the matter.
That's what we do. Questions?
Sure. Hope that was helpful.
Yeah, no, that is.
Can you just walk me through, I think only because I'm gonna have to talk about it on the floor, how the change on page 5, so not on the hindering, but the other change that was made, we did a person shall submit collection versus shall not refuse.
Can you, from my perspective, distinction without a difference?
Yeah, okay. That's kind of.
That's the way I read it. Shall submit. Yes, it takes out of it the element of, whether or not you're granting consent. But again, if a person's so inebriated that they're unconscious, we have the other DUI we can charge, which is impaired to the slightest degree. We don't need a reading on those folks generally.
Yeah.
The real purpose of this, from our perspective, was to bring into people into the DUI scheme who were in these impeding or obstruction cases that weren't really addressing the underlying criminogenic needs. We really wanted to get them into the DUI framework so that they can go through the process of being relicensed, getting a suspension, being relicensed, and also we're going to insure them. They're going to have to carry insurance, right? So they're going to have to insure themselves and their own acts against the public, right? So that they won't hurt people and people can't be have their needs met because they've done so. That was our concern.
Yeah. I just have memory from when we were looking at it that we had submit originally and then we turned it to refuse, shall not refuse for some reason.
Yeah, that was based on Judge Zonet's testimony that refuse is a well-defined phrase.
Yeah.
It, goes pretty far back in our DUI law. It wasn't in the initial statute back in 1917, but was in subsequent statutes before we have the scheme that we basically see now, which was, enacted in 1969. So.
Good. Yeah. So do you know what the rationale for switching it to submit if it's, I just want to,
and I'm only guessing, but it goes to how our warrants are drafted. The warrant tells the law enforcement officer that the law enforcement officer has to go and draw get the blood drawn. It doesn't tell the object, the person, the subject, that they have to do anything. Okay. And so saying refuse seems to be saying wait, you've got an obligation under this warrant, whereas submit means you're acknowledging there's a warrant there and you have to submit to it.
Okay.
Does that make sense?
Yeah. Thank you.
I think it has to do with that element. I don't know.
Yeah, and that's in line with what the defender general's testimony was, and said it was that you're removing it from that sort of consent to a document that you're not obligated to follow.
Yeah. Yeah. Okay.
Because it's an imposition on the law enforcement officer, the warrant itself, not an imposition on the subject.
Yeah. Yeah.
And our law acknowledges that. If you look at 1203, where it talks about the circumstances where you can get a warrant for blood when there's been a crash and someone's been injured or has been killed as a result, you have to get a separate order from the court to submit to that warrant if the person refuses.
Yeah. Okay. That's very helpful. Thank you.
I was just, it's been a long time since I practiced any kind of DUI law. Yeah, they have to be able.
Yeah,
So, but I do remember a few that fake consciousness.
yeah.
And, you know, you get to the hospital and the doctor says, no, they're fine. Watch, you know.
And it's a pretty high bar as far as
Yeah.
voluntary intoxication is concerned. You seriously have to be so drunk, you have no idea what you're doing.
Just instantly go for refusal.
Not that I haven't seen some people behind the wheel under those circumstances.
You didn't say, oh,
Well, the doctor did.
All right. Thank you very much.
Thank you.
So we'll hear from Wade, next, Wade Cochran, Director of Enforcement Safety. Thank you for being here.
Thank you. Good morning, Wade Cochran, Director of Enforcement and Safety. And I like going after Ben and Dennis because I have very little to add. We had a concern on page 1 with some wording with the CDL, and that has been changed. So we definitely agree with what has been changed to cover our federal guidelines that we have to go by. And that's pretty much what I have for this morning.
Well,
So-
we needed to have that on the record and hear that. So, any questions for them? Not seeing any. Thank you very much.
Thank you.
Yeah, no, go ahead, Ken.
what is the blood level for CDL?
CDL, I would have to look. I believe it's an 04. Dennis? Oh, yeah.
Four?
04, yeah.
Why did I think it was 2?
02 is for bus drivers.
Drivers.
Bus.
Yeah.
A bus for kids, right?
Correct. School bus.
Yeah.
Thank you.
Reasonable.
Yeah, Ian.
Okay, I will have one question.
Okay.
Do you feel good about, so we have I'm assuming the language for you specifically is lines 14 through 16 on page 1.
Correct.
Operating a commercial motor vehicle with any offense or violation of any traffic control law other than, so we have parking, vehicle weight, or vehicle defect violations. Do you feel comfortable that those 3 capture all of the things that you need in this?
We do, and we spoke to the staff attorney who felt that way as well, so should be good.
Go ahead.
And on that front, my understanding of better research is that also mirrors the CFR language.
It does.
Yeah, so we're bringing the same language into our statute.
Thanks.
Anything else? All right, thank you very much. All right, so we have 2 other witnesses, but they're not until after the floor, Marshall Paul and Judge Zone. But before we break, I would like to kind of finalize the S12 and where we are with that. I know that we've been talking about whether to keep essentially where we are right now with that one change for the pro se plaintiffs, defendants. I mean, I could take a straw poll on staying where we are and not dealing with the embezzlement, or people. I understand where Zach is. Do you want me to take a straw poll on that? Should I take a straw poll?
I think that's a moot point, but
Yeah, okay, all right.
I mean, looking for honest,
Yeah, no, that's fine.
it's a waste of time.
Yeah, okay. Because, yeah, I think I read probably the same way.
I'm not an idiot, so.
Okay, all right, so in that case, we will, Michelle will have the edited final version for us right after the floor. We'll vote on that, then we'll have the 2 additional